Hello there. The Prime Minister Boris Johnson keeps assuring us that the UK will leave the EU, deal or no deal, on the 31st of October. But doesn't that Remain-driven Surrender Act stop a no-deal Brexit? Now, just to start with a bit of a caution that some of this might be a bit hard to follow at first, but please do stick with it as I think you'll find it's worth it. So ever since he got into office, the Prime Minister has continually assured us that the UK will leave the EU, deal or no deal, on the 31st of October, do or die. And he reaffirmed that position last night in another of his 20-minute People's PMQs on social media. But the Remainers say they have an at least 95% watertight Act of Parliament in the form of this so-called Surrender Act that stops the no-deal scenario by forcing Boris himself to write to the EU Council on the 19th of October and beg the Council for Brexit to be extended again to 11 p.m. on the 31st of January 2020. And as this sort of thing has been done before, then most people assume it will have the same outcome. But I watched a short extract from a video where the Tory Brexiteer MP and lawyer Bill Cash said that because of a recently issued commencement order, the Withdrawal Act 2018 is now complete and that the Brexit date is therefore set at the 31st of October 2019. So I had to go away and give this some thought. Now, I've looked at this issue before and assumed that because the definition of exit day that would trigger the repeal of the European Communities Act 1972 and set the UK free from the EU, because that date can be amended by a Minister of the Crown, then all that needed to happen was a negotiation and agreement with the EU, then the date in the Withdrawal Act 2018 could be easily changed, just like last time with Theresa May. But on my layman's reflection, it may not now be quite as straightforward as that. And to explain this, I'm going to refer to three legal things. First, the Withdrawal Act 2018. Second, the act that was just passed by Parliament to stop the no deal and force the Prime Minister to write to Brussels for an extension, which I'll refer to as the Surrender Act. And third, a legal instrument called a commencement order. Now, to go back a bit, when the Withdrawal Act 2018 itself got royal assent, Section 1 of that Act was subject to a thing called commencement. That is, it would not come into force until the Prime Minister ordered it to come into force by using an instrument called a commencement order that would make it legally effective. And Section 1 of the Act is the bit that repeals the European Communities Act on exit day, so severing all legal ties with the European Union and shrugging off the shackles of the European Court of Justice. Now, when Theresa May twice extended Article 50, that section of the Withdrawal Act 2018 was not effective, as a commencement order had not yet been issued. So changing the date had no legal effect at all. But since Boris got into number 10, Article 1 of the 2018 Withdrawal Act has been brought into force by a commencement order. Up until that commencement order, there was actually no exit date in UK law. That means that now, in UK law, the exit date really is the 31st of October. But, you ask, doesn't this new Surrender Act change all of that? And that's where the real questions start. We have an Act of Parliament in the form of the Withdrawal Act 2018 that is now in force that says it is the will of Parliament to leave the EU on the 31st of October full stop. And we now have another Act of Parliament in the form of the Surrender Act that says it is the will of Parliament to change that exit date to another unspecified date in the future if the EU offers it. But the Surrender Act instructs Boris to write the letter to ask for an extension and agree to it before the date in the Withdrawal Act 2018 itself is amended, so he would be breaking UK law by doing so. no one can agree a treaty or a treaty change with an international partner without ensuring that the UK law is in line with it first. Can't do it after the fact. And remember that when Theresa May did it, there was no commencement order in place. Now, some people with a bit of more knowledge about these things will start talking about the concept of implied repeal, where all or parts of an earlier act can be repealed by a later act. But I'm not sure that could be argued here, as the drafters of the Surrender Act are relying on the very sections of the Withdrawal Act that would be affected by implied repeal to make their own act effective. There is also the matter of Section 5(3) of the Surrender Act that says, "The provisions of this Act override any statutory or other provision which would otherwise require the UK to leave the European Union on any specified date." Now, on the face of it, that clause applies to the exit date in the Withdrawal Act and potentially nullifies it. But the Withdrawal Act 2018 is now reflecting EU law as laid down in an EU Council decision. That is binding international law, as Remainers keep telling us. The Withdrawal Act 2018 is now channeling EU law and is therefore legally binding over UK law, even later statute law. That means therefore that no Act of Parliament written later can override it, like the Surrender Act purports to do. For example, consider EU data protection law or human rights law, for example. No UK Act of Parliament can say that it overrides those international laws, and if it did, and the case was taken to court, the judge would almost certainly reject it as an invalid law. Using that argument, it would mean that in both international and UK law, the Prime Minister is required to follow through on the Withdrawal Act 2018. Even revoking the Article 50 letter might come up against the same legal stumbling blocks. In fact, the Withdrawal Act 2018 may now be unassailable. So it would seem to me that the 2018 Withdrawal Act stands complete and unaffected by this new Surrender Act. The problem for the Remainers goes along the lines of, we need to change the date in the 2018 Withdrawal Act. But that date is set in stone by international law in the form of the EU Council decision. It is also now set in stone in UK law because of the commencement order. That UK law, because it reflects international law, cannot be changed except by changing international law. And no one can negotiate or agree to change international law without changing the UK law first, and back to the start. That could mean that if Boris does write a letter in accordance with the requirements of the Surrender Act, he would be acting in direct contravention of a superior act in the form of the Withdrawal Act that reflects international law. And Boris is always stating he won't be breaking the law, isn't he? All this, plus a couple of other issues in the Act that I and others have talked about in the last few days, might make the Surrender Act inoperable or unenforceable in law. And that might explain this feverishly hectic rush to get the prorogation quashed and Parliament recalled over the next few days before the Supreme Court makes its ruling on Tuesday, so as to give them the chance to iron out any problems in this legislation. But they have to overcome the supremacy of the Withdrawal Act 2018 itself first. Maybe. Anyway, what do you think? Please share and comment, and thank you for watching. Please do like and share this video, and also subscribe to my channel. And when subscribing, please do remember to press on the little bell next to the subscribe button. That way you'll get an alert every single time I put up a new video. Thank you very much for watching.